Okay, I want to welcome everybody to the Resident and Family Support Council that we have every other week. The purpose of this meeting is to help empower people with information so that people can have the life they need, want, and deserve as they are navigating the long-term care path. And so today we actually are going to have Barry Lowy, who is the director, the program director for the Illinois State Guardianship program. And but before Barry goes ahead and gives his presentation, we're going to have just Stephen Maxwell wants to share some information from Centers for Medicare and Medicaid Services regarding vaccination for employees who work in long-term care facilities. Stephen, you want to go ahead and unmute yourself?
Yeah, thanks, Lee. So something happened, I believe it was last Thursday, is CMS, Center for Medicare and Medicaid Services, released a new rule which requires long-term care facility staff to be vaccinated for COVID-19. I know Illinois has put in a rule, and it says that you can opt to test weekly instead of getting the vaccination. This rule closes that up, so you can only opt to test if you have a health or a religious reason for not getting the vaccine. So it's the rule, like I said, was laid out last Thursday. There are two phases for it coming into effect. The first phase comes into effect is December 6th. And the important thing for you all to know is that on that date, the nursing homes are supposed to have their vaccination policy laid out. And then on January 4th, they're supposed to, all of their staff are supposed to be vaccinated. So I'm bringing this to your attention for a couple of reasons. Number one, we don't know right now what effect this is going to have on staffing. And number two, there's uncertainty as I was reading through the rule as to whether essential caregivers will be required or not required to be vaccinated. I know some of you are essential caregivers. It does not sound like routine visitors will have to be vaccinated, but that's just something to keep an eye on. In the chat box, I posted an article on the just kind of the little bit about the rule, and then I also posted the comment section for the rule itself. Anytime a new rule is issued, the federal government has to leave it open for comment for a certain number of days. So I posted a link to the comments, and you can feel free to go there and give your opinion directly to the rule makers. So that's all I had, and Lee, back to you.
Okay. Well, thanks a lot, Stephen, for sharing all of that. That was our public service announcement for the day, and it's important information because I know it's forefront in so many people's minds right now, especially with the holiday season coming along. And it's just going to affect me being able to see my family members. So thank you so much, Stephen, for sharing that. Barry, I'm going to go ahead and pass the ball to you. You can go ahead and start sharing your screen. Like I said, Barry is the program director for the Illinois Office of State Guardianship, and he is going to talk to us today about guardianship here, which we know we've had a lot of questions about in the past. So hopefully he'll be able to help us navigate this path a little bit and understand this program a little bit better. Barry, I understand, is the guru on this topic. So we're very excited to have you, Barry. Thank you so much for joining us today.
Sure thing. Just a little bit by way of background is I was licensed to practice law in 1999, and I started working for a small family firm in Lake County about a year after that. And that's when my career in probate work got started, because my boss had a banker's box full of documents that needed to get organized and presented to the court. And he was very tardy, and the judge was threatening to put him in jail. So that was my my intro to probate. So I am the director of the Office of State Guardian. I have been so since January of 2017. For 19 years previous to that, I was in various capacities at Equip for Equality, which is the state's protection and advocacy agency. I actually had the pleasure of managing a grant from the Department on Aging to provide legal backup services to APS and ombudsman programs. So I got to really know and understand that system and come to really appreciate it. So what is guardianship? So, and I'm going to ask that folks, I can't see any questions that are in the chat box. So I'm going to have to deal with questions that arise after the presentation is over. So I do apologize for that. Normally I like to take and address questions as we go. So the most important thing to understand is guardianship is a legal relationship. And it basically puts in place a substitute decision maker for a person who can't fully manage their affairs. So due process is required. You can even have a jury trial if you want. The family members or any other interested party can become a guardian. The only disqualifiers, even people out of state can become guardians. The only disqualifier is if you have been convicted of a felony that is germane to the exercise of the duties of the guardian. So inability to manage affairs, not disability, is the basis for guardianship. And I think this is really important because a lot of individuals, they might be in a wheelchair, they might be totally paralyzed, and yet they're sharp as brass tacks and can self-direct their care and their desires and wants in their environment. My mother had multiple sclerosis and was in a nursing home when I was a boy and a young man, and there was there never would have occurred to me to ever thought about getting guardianship for her. She was just so capable even with her disability. So it should be seen as a tool of last resort. In fact, our Probate Act says that it's to be ordered only to the extent necessary. And it's a mechanism to protect the individual from harm. You see that through the APS function and appointing our agency as guardian in instances when folks have been subjected to abuse and neglect, exploitation. But the thing it's supposed to do is you're supposed to not only protect the individual from harm, but you're to encourage the development of maximum self-reliance and independence. That's right in the Probate Act. So temporary guardianships are good for 60 days. They can be renewed once. Then you have guardianship of the person. You have guardianship of the estate. Plenary means that all the authority in the Probate Act is conferred upon the guardian.
Barry,
Limited.
if I can interrupt for 1 second. Are you using your slides right now?
Yes.
We can't see those. So the screen
Okay.
share did not go through.
Oh, okay. So let me see if I can figure out how to get out of here. Okay. So screen share did not go through. Oh boy. You gotta love technology.
And while you're figuring that out, a question just came up. Yes, we will be posting these slides on our website. And we also have a YouTube station now. So this is being recorded and will be on the YouTube channel for the Illinois Ombudsman Program.
I think you're still sharing your screen is why mine's not working.
It doesn't say it is.
Choose what to share. Well, hold on a second. Choose what to share entire screen. Share. Hold on.
It's okay. Yep, looks like it's starting. Yep.
Okay, so oops, that's not it. Can you see it now?
Yes, we can.
Okay, great.
Now you just probably need to make it onto the screen so we don't see all your slides unless you
Oh
want
yeah, sure. I gotta go back to the slide.
No, you could just click on the bottom button there.
It says stop sharing. I'm just gonna go slideshow. Where is it?
Yeah.
From current slide. Okay.
There we go. Perfect.
All righty.
Okay.
So the thing to understand about guardianship is we want to use it to the extent necessary. And so every category of guardianship essentially has an advanced directive counterpart. So for instance, the guardianship of the person. You could certainly use a durable power of attorney for property, healthcare power of attorney, mental health advanced directive. Those are all outside the judicial context, whereas guardianship is inside the judicial context. So if say a family member is looking to assist their child with a disability, say, and they don't want to take away their autonomy and their rights. An advance directive is something that can be looked towards. One of the things that just passed in Illinois is the Supported Decision-Making Act. And so now for at least for folks with intellectual disabilities, that's who it applies to, is those with IDDD. For those individuals, they can enter into a supporting document where they designate a person. They're not an agent, such as a power of attorney, because the person with the disability still retains the full decision-making component of the relationship, but the other person's in the room to help assist. And the law provides that things like confidentiality acts do not apply to the supporter when they're acting in their supporting role. So why do we seek to obtain guardianship? Well, there's a number of reasons why. To help assist a person in accessing services when they can't do so themselves. And again, I want to reiterate that that is a component where, at least for IDDD folks, that supported decision-making agreement can be in place. Again, guardians can also obtain confidential records. The HIPAA laws do not apply to guardianships. The obvious one is to help manage financial affairs, especially if, say, a family member who they're living with is financially exploiting the heck out of them. You can go in and get a protective guardianship to put a stop to that. And then, of course, the determination to make residential placement decisions is something that is granted to guardians. I talked about that. So generally, a physician's report is required. In Illinois, there was another recent law that's going to go into effect, I believe, January. For folks with intellectual disabilities, a petition for guardianship can be supported by a psychological evaluation now, not necessarily the report of a physician, but a report of a physician is always available with respect to all individuals for whom a petition might be brought against. The report can't be stale. It's got to be done within the last 3 months, and it has to be signed by the physician, or in the case of a person with IDDD, by the psychologist, not a student working under the psychologist. One of the things that gets confused an awful lot with respect to court matters that are proceeding in probate to appoint a guardian, before the guardian gets appointed, the court will often appoint a guardian ad litem. I've had judges even misunderstand what the purpose and role of the guardian ad litem is. Essentially, the guardian ad litem is another term would be court investigator. They're the eyes and ears of the court. They're supposed to personally observe the respondent. They're supposed to serve them with the petition and advise them of their rights, including the right to appear in court and contest it. And then the GAL is supposed to report back to the court, what their determination is as far as need for guardianship and whether it needs to be planning or limited, and if limited, to what extent. The thing about a limited guardianship is it can be expansive or it can be very limited. For example, I've had a couple of cases at Equip for Equality where this came up. One of the things that Equip was really loath to do was to do anything about getting a person to guardian. They viewed themselves as contesting guardianships as their role. I had a client that was, he had a mild intellectual disability, but he was also deaf, and he also was nonverbal. He could make noises, but he really couldn't speak the English language. But he understood sign, and he basically lived at home and saved over $250,000 washing cars down at the dealership that his dad was friends with. The parents passed away. He continued to live in the house, and the guy on the block started taking advantage of him, passing himself off as his nephew. Ultimately, he bought a boat, bought a motorcycle with the guy's money, and got a kind of a siding slap job down on the house to get money out on a second mortgage type thing, or it actually was a primary mortgage. And he didn't understand what he was signing, and the bank moved to foreclose. And I made a capacity defense. I mean, a mortgage is essentially a contract, and to enter into a contract, you have to have capacity. And I argued to the bank's lawyers that he didn't have capacity, and I provided some records, and they said, then I made a settlement offer. I offered that he would pay $50 a month to live there, and when he passed, the bank could then come take the house. He had no living heirs at that point in time. Well, the bank said, counsel, you're very clever in having convinced us that your client doesn't have capacity to to enter into a contract. So how's he going to sign the settlement agreement? And so I was able to convince my superiors at Equip that we could go into court, and we got a limited guardianship for the sole purpose of signing that settlement agreement, and then it was done. Conversely, I had another case where a father was financially exploiting his son, and we got the father removed as guardian, and we got the public guardian appointed, and I had a 6-page order setting forth all the responsibilities of the public guardian. And when they were all met and done, I told the court it's time to close this case. The father's attorney objected, and the court said, nope, the limited guardianship is for the things specified, and all things specified are done here. But again, that was a 7-page order as opposed to a 1-paragraph order in the other one. So limited guardians should be favored in the state, but structurally, the way probate cases are handled, they're the rarity, not the rule. The one thing to understand is that the guardian ad litem is not the respondent's attorney. They are there to basically make an assessment and to render an opinion as to the need for guardianship. A guardian has the right to express a preference for the person to be appointed guardian. And in guardianship cases, this is important when you have two competing, say, family members, perhaps going through a divorce, who are seeking to get the Social Security money of the ward, and they're fighting over it. And so the ward could express a preference for who they would want to be guardian. I had a case similar, such as that, where the daughter was living with the mother, and she expressed her preference and to stay with her mom if a need for guardianship was necessary. But we were able to convince the court that natural supports rendered it such that the guardianship was unnecessary, and so the court did not end up appointing a guardian, although she was able to express her preferences for guardian. Powers of attorneys. People often ask, well, I've got a power of attorney, should we go get a guardian? A lot of times service providers won't recognize the power of attorney and will say, you've got to go get a guardian. That is the most uninformed statement with respect to powers of attorneys and to interplay with guardians. The law is absolutely clear that guardians take their guardianship authority subject to any prior powers of attorneys that exist. And so the person petitioning to appoint the guardian has to petition to terminate that power of attorney. And if it's a temporary proceeding, they can ask that it be suspended during the pendency of the limited. But ultimately, if a plenary is being sought, it has to be revoked, or the guardian takes subject to the power of attorney. And there's logic behind that. The logic is this: when I had capacity, I was able to express a preference for who I trusted to make decisions in my life. Now I lack capacity, and a guardian needs to be appointed for me. Do we go with some stranger, or do we go with the person with whom I trust and have designated to be my agent? And so that's the underlying logic behind that rule. So one of the things that a guardian has to submit to the court when they get appointed is an oath and bond. Oath is basically a statement that they will, an attestation under oath to the court that I will faithfully perform my duties as a guardian. So if they then start going off and doing their own thing and to the detriment of the ward, dipping into the till, so to speak, or self-dealing, you violated your oath. And at that point in time, you're subject to being revoked. The bond is basically an insurance policy that ensures the faithful performance of the duties. The public guardians have a general bond. Private parties have to post an individual bond. The Office of State Guardian does not have to post bond. Talk about that. So duties. What are the duties of the guardian of the estate? It's basically anything that deals with money and debt. It's in our agency, we call it marshaling assets. We will go out after we've been appointed a guardian, if we're guardian of the estate. We will go out and we will rummage through the person's home. We will look for Social Security cards, uncashed checks, sometimes money sewn into drapery. We'll take title and keys to cars. We'll look for other deeds to say property. Anything like if we could find a will or anything of other value. And we then compile all that together and we prepare what is called an inventory. So anything that's of value the court has to be told about it. And if that's not on the inventory, that's a violation of the guardian's oath. And so they have a responsibility to faithfully inventory and to frugally care, manage, and invest the estate. Putting it in a 0.03 interest savings account is not considered frugal investment. You know, putting it into a low risk mutual fund or something of that nature is considered by the court to be a more appropriate investment of money. And with the guardian of the estate, they're supposed to provide for the comfort and suitable support and education of the ward and their dependent children. And basically, providing for that comfort means cutting the check. Okay, they're not necessarily the ones who are going to be going out and locating apartments and things of that nature. Although many guardians do that. Institutional guardians can assist with that, but generally, the Office of State Guardian relies on service providers and community organizations and agencies to assist in providing for these things. And then finally, you have to annually account to the court for income and expenses. So basically, you present to the court a ledger of what happened over the last year. If the court hasn't ordered it to be done annually, the Probate Act says it's got to be done every 3 years. Failing to do an annual account is really can be really serious to the guardian and can really put them in jeopardy. Had several cases of quit for equality where there was some allegation that a guardian was financially exploiting the ward, had never filed an annual account. Particularly downstate, the courts don't necessarily keep good tabs on these things. If you're up in Cook and the Collar counties, you'll get a citation to come in and show why you shouldn't be held in contempt of court for failing to file your annual accounting. But if the accounting's not filed and it's not properly approved by the court, and then allegations are made that the guardian is financially exploiting the ward, that creates a presumption of fraud. And what that presumption of fraud does is it flips the burden of proof onto the guardian to show how they spent the money. And I've had instances where an account has been due for the last 17 years, and there's no way that that guardian is going to be able to provide the receipts necessary to support the expenses and the expenditures that they made. And so they're on the hook personally for that, plus the attorney's fees that are incurred in going through that process. A guardian of the estate cannot sell or mortgage real estate absent a court order, and for significant properties such as an automobile, a boat, motorcycle, etc., you also have to go to court and get a court order. Many of the places where we go into, they're in squalor, and there are torn and soiled clothes all over the place. We certainly don't inventory that to the court. We just indicate to the court miscellaneous personal items. So these are for things of value. Let's talk about the duties of the personal guardian. So the guardian takes custody of the ward. That's a legal terminology for having responsibility for the ward. It doesn't mean that they have physical custody and have to bring them home with them. And again, they have to make provision for the support, care, comfort, health, education, professional services, et cetera, et cetera, et cetera. Anything that doesn't involve their money, they have to see to it that it's there. And if there is a guardian of the estate, they go to the guardian of the estate to get the funds necessary to cover those costs. Now, their medical procedures, a little bit different. So we'll get to the medical stuff in a little bit. But there has been a recent change in the Probate Act. Let me see. Yeah. Okay. So a guardian is supposed to make decisions that conform to what the ward would have done if competent. Giving my example, let's say, of, I'm okay today, but tomorrow I get involved in a serious car accident and now I need a guardian. Well, let's say I need a blood transfusion and I'm of the type of religious beliefs that's morally opposed to having a blood transfusion. So if I've made my wishes known and a guardian gets appointed, let's say it's my niece who knows my wishes. If she's using appropriate substituted judgment decision-making standard, that person will not consent to giving me a blood transfusion. So that will let me die because they're following what I would have done had I been competent. Because if I was in that bed, and I was competent, I would tell the doctor, I'm not going to have that blood transfusion, which would be completely within my rights. And so let's say that those wishes were not made known to the guardian. Say it's the OSG that gets appointed at the last minute to make a determination to consent to a blood transfusion. Well, we wouldn't have the knowledge of what the ward wanted because we're flying in the dark. And so you then fall back onto what's known as best interest decision-making standards. And clearly it would be in the best interest of that person to receive that blood transfusion. They may not be happy about it later if they regain competency or consciousness, but we would have no choice because we wouldn't have available to us those wishes and therefore couldn't use substituted judgment. Substituted judgment is a little bit of a confusing term. What it really means is that the guardian is substituting the ward's judgment for their own judgment, not the other way around. And so I indicated again that a duty of the guardian of the person is to maximize the ward's independence and self-reliance. And it says it shall assist them. And this is applicable to all aspects of life: community integration, skill development, work, leisure, residential placement, etc. I one time went into court and argued that a person should be gotten out of a nursing home and allowed to reside in their own apartment. And I pointed that this was in the Probate Act out to the judge, and the judge looked at me and said, "Counsel, that's in the Probate Act?" So many instances you'll have a judge that's not familiar with the stuff on the person side of the equation. I'm on a video here, Darren. And so, pardon me, again, working from home, what it has its moments. So we talked about supportive decision-making, and basically that's putting the person with the disability into the center of the conversation. And rather than just doing what's best for the person, it kind of creates a synergy where you're involving the person with the disability and you're performing a balancing act. The recent amendments to the substituted judgment provisions of the Probate Act provide that the guardian must incorporate the ward to the extent of the ability of that ward. And I think it's important to point out that ability to participate in decision making is an elastic concept that's context sensitive. Some wards might be able to make certain basic decisions, like maybe I want to go see the Cubs rather than the Cardinals this week. But certainly when it comes to larger things such as an amputation or a serious surgical procedure, they wouldn't have the capacity to do that. So then the guardian would be acting under their best interest standard. So guardians making healthcare decisions generally act under the Healthcare Surrogate Act, particularly if it's an end-of-life decision matter. And the Healthcare Surrogate Act requires that 2 doctors make 2 written findings after an exam showing that the ward lacks decisional capacity and has a qualifying condition. Again, there was considerable work done this session on a number of these standards, and OSG and the Pulse folks worked together to amend the Healthcare Surrogate Act. And now what's required is that you have 1 doctor make a written finding, and that another healthcare professional, such as a nurse practitioner, advanced practice nurse, resident intern, they can make the second finding. That the person basically, what a qualifying condition is that you're basically dying, and nothing we can do is going to stop that process. And all we can do is prolong that process and thereby increase your suffering. And so once that test is met and the court makes a determination that the ward lacks decisional capacity, the surrogate decision maker is empowered to act. The Healthcare Surrogate Act sets forth a hierarchy of individuals who are authorized to act in an order of preference. The number 1 order of preference is guardian of the person, and then you get into spouses and parents and children and etc. And so that's the reason why we're called upon to make a number of these end-of-life decisions, because we're generally the guardian of the person and we're first in line under the Healthcare Surrogate Act. One of the things that we're always on the lookout for with respect to that decisional capacity is we will get requests for DNRs, written requests for DNRs from doctors who fill out our form, and their basis for claiming that the ward lacks decisional capacity is they'll literally write has mental retardation. Well, under the Healthcare Surrogate Act, there's a provision that specifically states that mental illness and intellectual disability of themselves are not a basis for a finding of lacking decisional capacity. And so when we get those types of requests from physicians, we will not grant them. It says a lot about the doctor that they're still using the term mental retardation. And it also says a lot about the value of that person's life in the eyes of that physician. And so we won't consent to those, and nor should anybody else. One thing I really want to stress the importance of is the difference between decisional capacity and legal competency. Decisional capacity is the right to make their own health decisions. The preamble to the Healthcare Surrogate Act says that the ability to make your own medical decisions is a fundamental right. And so even under guardianship, a person who has decisional capacity still retains that fundamental right to make decisions as to their own health care. It's when the doctor says that this person lacks decisional capacity that the guardian then becomes empowered to make the decision. So one of the things that had been in the law for the longest time was the right of a guardian to basically take their ward, generally a daughter or son, to the hospital and or to the doctor and have a procedure done that would sterilize them. And they would do it on their own authority without any hearing from the court or any finding by the court regarding the person's capacity and preferences. So that's all changed now. So there was a case called KEJ, and that now requires the guardian to go into court and make a determination that the person lacks decisional capacity. If the court finds that the person has capacity, the hearing stops at that point in time, and the court has to follow the wishes of the ward in whether they want to be sterilized or whether they don't want to be sterilized. If the finding is that the person lacks decisional capacity, the court moves forward through a best interest test and makes a determination based upon the ward's best interest. So there's a case. I was actually the attorney that handled the case when I was at EQIP, and it was actually brought against the Office of State Guardian. We had a woman that was in a mental health facility that had a locked behavior unit that was discrete from the rest of the unit, the rest of the nursing home. And she'd been hospitalized. This woman, she had schizophrenia, and her doctor told her essentially that she was getting tardive dyskinesia from her medications. So she went off of them. She became very delusional. What she would do is she would open her blouse and put a towel on her breast because she was delusional that she still had her babies. She lost her babies to the state years before. She had actually been in McFarland when she gave birth. It's a very sad situation for this woman. So she checked herself in voluntarily in the hospital, and then the hospital decided to stick her in a nursing home against her will. And when she had an apartment, I actually was able to go in and see her apartment. It was neat. She had some food in the refrigerator, but she was just totally delusional. She wasn't dangerous to anybody. She wasn't even dangerous to herself. But here she was in this locked unit. We argued that that was inappropriate and that under the mental health code, there had to be a hearing, and the higher standards of proof set forth under the mental health code had to proceed. So as a result of the Mueller case, guardians do not have the authority to admit their wards into a mental health facility against their will. Same thing with forcing psychotropic medications. Okay. So the mental health code controls placement of individuals with mental illness, and it also controls the placement of folks with developmental disabilities and intellectual disabilities into residential placement. Sorry about that. I had the one phone on mute, not the other phone. The difference, the reason why a guardian lacks the authority to put a person with mental illness in a facility for treatment, while they have the authority to do so for a person with a developmental disability, rests on the fact that there is a paragraph on the mental health side of the code that specifically says that a guardian doesn't have that authority, basically. Whereas on the DD side of the code, it says that a guardian may make an administrative admission of a ward with DD into a facility. So there's authority on the developmental disability side of the code, that's section 300, whereas under section 200, that's absent. So when it comes to residential placements, a guardian is not supposed to remove the ward from his or her home or separate them from family and friends unless it's necessary to prevent harm. So we don't want to socially isolate individuals when making residential placements. And when making residential placement, the guardian really is to follow what the ward's wishes are, again, unless it causes harm to their estate or to their person. We talked about limited guardianship. So let's talk about some of the fundamental rights that a guardian retains. A guardian has the right to marry, so long as they understand the nature of the relationship. So if a guardian doesn't like the person they're marrying, that guardian has to go into court and explain to the court why that person doesn't have the capacity to understand the nature of the marriage. And basically, I don't like the guy or I don't like the woman isn't a basis for denying that person's fundamental right to marry, because it is a fundamental right. Now, what's interesting is persons under guardianship, there is a question as to whether they have that capacity to understand the nature. And so it's not bulletproof, but there is a way to make it bulletproof. What the guardian can do is, if they like the person, let's say, and they want to make sure this thing is on solid legal ground, this marriage, they can go into court and petition the judge for leave to consent to the marriage, and the court will go through and make a capacity determination on the ward's ability to understand the nature of marriage. And then that prevents third parties from coming in and trying to contest it later based upon their capacity. It used to be that a guardian could not seek a divorce. That changed, and it changed because the new case law recognized the fact that Illinois is now a fault state rather than before. I should say that, excuse me, it's a no fault state, whereas before, under the old case law, it was a fault state. And so now a guardian has to go to court and petition for leave to file the divorce papers. So guardianships can be forever, or they can be revoked or modified. So the ward has the absolute right to go back to court and request that another person be appointed guardian, or that the guardian's power be limited, or that, say, the guardian of the person be terminated, but that the guardian of the estate remain because they need help with managing money. They can be tweaked and adjusted however the circumstances cause for. A guardian can be removed for any good cause. And so it doesn't necessarily have to be malfeasance or misfeasance, but those are generally the reasons why you would remove a guardian. And then there are restoration proceedings. We restore, I would say, between 12 and 24 wards every year. Things change in their life. They get on their feet. They learn. They develop tools and skills, and they just don't need a guardian anymore. And we'll go into court and petition to have the guardianship terminated. Under the restoration statute, if the ward has a physician's statement that they should be restored, and the guardian agrees that it's in the best interest to restore the ward. Now, it's a best interest test there that the guardian uses, not substituted judgment. So the ward is coming forward with a doctor's report. The ward also has to say, I want to be restored. And then the guardian says they want to be restored. That shifts the burden of proof to show to somebody who wants that guardianship to remain in place. So a third party has to come into court, has to object, and has to provide sufficient proof to show by clear and convincing evidence that that ward should remain under guardianship. In essence, when those three things align, you basically have a presumption that they should be restored. So that's the end of the presentation. It was a kind of a survey course, if you will, into guardianship. And so I take it we will be opening it to the floor.
Yes, we will. If you have any questions, please don't hesitate to put those into the chat box, or if it's a more complicated question and it's too much to type, you can go ahead and unmute yourself and ask the question directly. And while we're waiting to see if we get any questions, I did want to ask you, Barry, about can anybody just become a guardian? Is there any training or anything along those lines that a guardian has to have?
Right. I didn't, this was a brief presentation, but yes, one of the first things I did when I became the director of this agency, there was a bill that was being worked on. I kind of tweaked it and shuffled it around where it belongs in the Probate Act, but guardians outside of Cook County have 1 year to complete a guardianship training that can be found on our website. I with a couple other folks, develop that training. And I've been told it takes between 20 minutes and a half hour, and that folks find it accessible and informational. There's 2 versions of it. There's a version where you get a certificate that you file with the court so that you meet your 1-year deadline and prove to the court you've taken it. The court, of course, can excuse you from having to take it. You can say, hey, judge, I was a guardian before, I know what I'm doing, blah, blah, blah. And the court can be convinced and decide, okay, you're excused from that requirement. So for good cause, the court can make a finding that you don't have to take it. But if you're appointed outside of Cook County, and that might change in the future to include Cook County, but if you're appointed outside of Cook County, you have to take that course. It's also available for folks that, and to get the certificate, you have to register, because we have to know what county to fill the certificate out in, and what court it goes to, et cetera, and the case number. But if you just want the information, it's available on our website as well, and you can just go and run through the slides yourselves. And it's a pretty good primer of guardianship laws and responsibilities of the guardian.
And what is that website? Your website, which one would that be?
I believe it's www.gac.gov.
Okay, great.
I've got it bookmarked as a favorite.
Yeah, I know. I know how that goes. Yeah.
Yeah, all you have to do is go in and type Illinois Guardianship and Advocacy Commission, and our website will pop right up.
Okay, and that's something, and everyone must have that.
Where you find it is there's tabs down the right-hand side, and at the bottom tab it says Guardianship Trainings.
Okay, yeah, I know. I've looked at that training myself, and I've actually have taken it just to get more familiar with the program, because it does feel that this can be a very complicated, law-based. There's so many levels to this program, so we really do appreciate everything that you shared with us today.
One of the other things that's on our website along with the trainings is Teresa Parks compiled that. She did an excellent job. It's a resource guide of where to turn to, for instance, like where to report abuse, so the Department on Aging, where to report child abuse, DCFS, et cetera, public health stuff, other websites, Equipped for Qualities. There's a whole host of resources that are available on our website too.
Okay, yeah, that's important. We've had Teresa talk with the group as well. I mean, she shared some of the things, maybe some of those resources which were really, really valuable and really important. Stephen, is there a question?
Yeah, and Lee, I just wanted to point out that first, Barry, could you stop sharing your screen?
Oh.
I think
yeah,
it's throwing me off because I'm seeing myself 3 times now.
I'm used to WebEx, not so much Zoom.
Yeah.
So anyway, I posted a link to the guardianship training if anyone's interested in it. And I honestly, I can say if you are an ombudsman or any sort of senior advocate, if you're looking at guardianship, or if you're potentially going to come under a guardianship, that is a really good training to look at and go through. It's very informative, and it informs the person going under the guardianship of their rights and the restrictions on the guardian, and it informs the guardian what they can and cannot do. We did have a comment come up. Haven't read it to see if it's a question yet, but says, as guardian of adult daughter, I am getting up in age and my spouse is already deceased. In event of my daughter and I have, in the event of my death, I only have one other daughter. Do I ensure she becomes guardian? My daughter, who is disabled, is 59. Mia, 39 years, also has TBI, short-term memory loss, plus many physical disabilities. So it looks like, how does she ensure that her other daughter becomes the guardian for her disabled daughter?
Yeah, I think you're there. Is that the question you wanted to ask? Okay, great.
Yeah. Yes.
Well, that can go a couple of different ways, but I think the most, it sounds to me like you're really looking for some assurance and some certainty in your future with this situation. So if you really want to get proactive, in your planning for this. What you can do is you could go to the court. Your daughter would have to provide an oath and bond, unless the court waives bond. I've seen instances where like the person's getting nothing but Social Security and there's a rep payee in place. But basically what would happen is you would go into court on a petition to appoint a co-guardian, and you would bring your daughter in as co-guardian. Now, one of the things to remember about co-guardianship is each guardian has full authority to make decisions. So if your daughter disagrees with you on something, she has every much a right to disagree with you or you with her. So generally, you really have to be on the same page for that to work. A lot of times you'll see, it might even be that your husband was the co-guardian prior to that, but any interested person can become a co-guardian. It could even be the pastor of your church or, whatever. But obviously, the most logical choice would be your daughter as co-guardian.
Does that answer your question, or do you have more questions?
Yes, the daughter is in another state at this time, and I'm almost 80 years old is my concern. Do I need to put this in writing somewhere? I mean, that's what my concern.
You would need a court order in the probate case.
Okay.
Yeah, expressing your wishes in writing. You can express a preference for your own guardian in a will, and powers of attorney and things of that nature. But really, the safest bet for you, and being out of state is not preclusive in Illinois of being a guardian. So you can be an out-of-state guardian.
So
Yeah,
thank you.
Yeah, that was a great question. We had another question come up. Barry, does your office have a section or division which works specifically on financial exploitation?
Well, that's kind of I can answer that in many different ways, but let me put it this way: when we can be appointed as guardian of the person, we can be appointed as guardian of the estate. So let's say we're appointed guardian of the person, and let's say they're living with somebody, and then we come to realize that there's financial exploitation. We will go into court and seek to have ourselves appointed as guardian of the estate. Once we're appointed as a guardian, we don't generally petition to be appointed as a guardian, but if we need to expand our authority to protect our wards, we will do so. We downstate we have caseworkers that are both guardians of the person and estate, so they do the estate work. The estate work really is where the action's at when you're talking about preventing financial exploitation. In Chicago and the collar counties, we have a dedicated estate unit that does nothing but estate work, and we have 4 caseworkers in it, and they work very closely with our attorneys. But as far as being, say, a community watchdog regarding financial exploitation, I mean, that might fall a little bit more in the area that HRA and Teresa Parks might handle, but generally that's an APS function, and we get cases from APS on that aspect.
And APS stands for Adult Protective Services.
Correct.
For those who may not be aware of that, and they are out there to make sure that things like that, there is not financial exploitation. And if you need any assistance with any of this, because sometimes, you might be going through something and you're not quite hearing it all right now, but because of the situation that you're in, you can always reach out to the ombudsman, who can also help direct for where that can go, and how we can help advocate for you is by giving you information to help empower you to be able to move forward with things like that. So,
and Ombudsman program contact information is at the top of the chat.
Great. Thank you for that, Stephen. I do want to talk just a little bit about this power of attorney for healthcare thing that you brought up, as well as, like, you talked about that situation that happens, the car accident, and you need the blood, you need a blood transfusion, and your guardian, maybe the guardian doesn't understand your religious needs, but somebody else in the family might understand your religious needs, and they say to the guardian, no, he wouldn't want that, but the guardian's like, well, I don't know that for sure. So does the guardian take into consideration other people around the individual that knew the individual and may have known them better, or for things like that?
Well, there's a legal answer to that and a practical answer to that. The legal answer is the Probate Act specifically says that the guardian is to take into consideration the ward's family, friends, people that know them with respect to their philosophical and religious and other beliefs. So it's specifically written into the Probate Act that those persons are supposed to be consulted by the guardian. Now, whether the guardian is acting in conformity with those provisions or is basically saying it's my way or the highway, that can occur. I've tried very hard in this organization to make sure that it doesn't. And when I was at Equip for Equality, I worked very hard to make sure that those guardians that acted that way got removed. And so the answer to that question is yes, but in practicality, sometimes that gets ignored.
Yeah, because that's something that we will see as ombudsmen sometimes. There's somebody that lives in a nursing home, for example, and the resident, it tells us that they want this, and they want this, and they want this, and there's things that they want, and they seem to be able to articulate very clearly what it is that they want, and their guardian is saying, no, I'm not going to allow that to happen.
Right, and the recent changes to the law that frankly GAC pushed, and I was the front person on pushing it. Specifically says that the guardian is to make decisions, basically what the ward is expressing. They have to honor the ward's wishes to the level that the ward can participate in the decision-making process. And so not only are those provisions of talking to other people about what they want when they say they had capacity, they're also supposed to talk to the person now about what they want, even though they're under guardianship. And it kind of is what it's doing is it's kind of expanding the concept of decisional capacity beyond just the healthcare provisions, but into all facets of life. So that the person with the disability is empowered and put in the center of the conversation to make decisions about themselves when they can.
And
they can't always.
We seem to see this a lot with people that have, mental illness, and it seems that, that question of capacity gets overridden a lot by a facility who they'll listen to a guardian more so than they will listen to the individual. And then that's when we come in and we have a bit of a battle that can happen because the guardian is saying one thing and the resident saying the other, and the facility's like, no, we got to listen to the guardian. It's like, no, you have to listen to the resident. And that gets...
And I think arming yourself with the current version of paragraph 17E of the Probate Act would go a long way in educating them. But I've dealt with facilities for decades, and they sometimes do what they want to do.
Yeah, but sometimes I feel like it's a lack of information. I think they just think the guardian makes all decisions for the individual. That's what I've always heard my whole life. That's what the layman would think until we have a conversation like we're having today. Because I think it completely gets misconstrued by the general public.
And not only do that, but let's say I had a client that wanted a laptop computer because she was in a modified curriculum at Lincoln Land Community College. And she needed a laptop to do her homework. And her mother was her guardian, and she was an evil woman. I mean, we fought for years. She finally, when I left and became director of OSG, the attorney who I actually supervised finally went into court and got her removed and got OSG appointed as this young lady's guardian. But the facility she was in with a SILA provider. The SILA provider absolutely would not take her money and buy a laptop because the mom said no. But the thing was, and I kept arguing with them, listen, the mother's only guardian of the person. She's not guardian of the estate, and she has no say-so over her money. Buy her the dang laptop. The mother was like, she'll search porn on the internet. It's like she's using it for her homework.
And if she did search porn, who cares? It's her personal need, desire.
So we had another question come up. Guardianship of mentally ill child, drug addicted, homeless, needs to be in a protective environment. Is an adult child. What can be done?
Well, I'm kind of the guy that's hoisting his own petard here, but basically what you have to do is you have to either there has to be some sort of law enforcement involvement. Well, and under the code they're called peace officers. Or you have to, any interested person can also bring a petition for commitment under the mental health code. But it's problematic. I mean, if the person's not dangerous to themselves or others, and is not deteriorating because they've gone off their meds, a lot of hospitals won't find the term of art under the mental health code is you're a person subject to commitment. So a lot of hospitals, the cops will bring them in or family will bring them in. They'll calm down, they'll de-escalate, they'll be sitting in the hospital for a couple, 3 hours in the emergency room, nice and calm. And the hospital's like, we don't see any evidence of this. And so they cut them loose and back at it. It's a very difficult cycle. And particularly if the person's refusing help and is instead trying to self-medicate, basically they've got to meet the standards under the mental health code to force the treatment on them. Otherwise, they have autonomy to refuse mental health treatment, even though they might be very, very, very ill.
So we had another question come up, but we are getting towards the end of our time. So Lee, what do we have going on at our next meeting?
Our next meeting's topic is, okay, now you put me on the,
Sorry.
yeah, I'm trying to think. So that would be right before Thanksgiving. Our next meeting topic is, Stephen, I don't remember, and it was up on the pre-slide. So let me find.
You know what? I'll
Well,
ask
you
the
find that out.
question. I'll
Yep.
ask the question, and I'll let you find out. So our next question is, when you receive cases pertaining to financial exploitation from APS, how then do you resolve or investigate if there is actually investment fraud in particular? I think that's a question for Barry.
Yeah.
Not sure if he's still here or not.
Oh, I'm here.
Okay.
I thought my side of the gig here was done. So
Sorry, I should have given more warning.
yeah. So the question involved, what does OSG do when APS refers us a case, or?
Yes.
Well, I mean, obviously, one of the things that I heard when I was managing the grant for APS work and ombudsman work is I would go to the AAAs, and the number one complaint from the APS caseworkers were, why isn't OSG going in and petitioning for guardianship? And truly we're not precluded from going in and doing it. And the look is like, okay, we're going to be jumping in to protect people, but they're in so many states where the state brings its authority to take a person under guardianship and then strip them of their rights and take their money and things of that nature. It's not an optic that OSG wants to step into. And so we don't petition for guardianship. So APS has to dedicate some of its emergency response money to hiring an attorney to then petition. And that if that petition is brought and the court hears it and appoints us, I mean, the only time we really go in and object to an appointment is when a petitioner is trying to appoint us to deliver consents solely for healthcare against the person's wishes because of the Mueller case. That forms the basis of our objection. But in all other instances, when APS goes forward and gets a petition and gets it granted, we accept the case. Now, one of the things that we do find sometimes with APS is, OSG is supposed to be appointed only when there's no other quote unquote suitable and willing person to act. And so there might be family members out there that are suitable, but they don't want to have anything to do with the guardianship. So then we get those cases. And then there's all kinds of families where they're willing, but boy, oh boy, they're not suitable. And so we get those cases. And so, but if there is a family member who's both suitable and willing, then we need to be finding out about that. And sometimes APS is getting us appointed on cases where there's family members, and then we have to go take our resources and go back in and try to get the family member appointed and have us step out of the case. But yeah, APS cases come to us with regularity.
Well, Barry, I want to thank you very much for being with us today. And Stephen, the topic for next time, which the meeting is on the November 23rd, so that's Thanksgiving week. So we thought we would do something around the holidays, and the topic is going to be home for the holidays, enjoying each other company no matter where you live. So we want to be talking about things that you can do with your families as the holiday season is approaching us to help connect with each other, especially in this time of COVID. So that's what we'll be talking about next time. We want to encourage anybody who's participating to also bring any ideas that you may have. I'm going to go ahead and I'm going to launch our poll, which is just going to include about how you found today's meeting. And if you could please just go ahead and click one of those, very beneficial or not beneficial. We appreciate that. That helps guide us in other topics that we may be having moving forward. I want to thank everybody for attending today's really beneficial conversation. And again, thank you very much, Barry, for being here today. I'm going to go ahead and I'm stopping the recording now.